The Supreme speak. The broadcast begins in 10 seconds. WDBC Internet Television is on. I am an avatar for Michael P. Borgia. The broadcast, originating from deep behind enemy lines, is brought to you by DailyBorg.com. Conservative politics for the thoughtful. Resistance is futile. You will be assimilated. Each year, the most tumultuous week in American politics is the last week in June. That's when the Supreme Court releases rulings in its most high-profile cases. This year has been no different, with landmark rulings expected on affirmative action, the Voting Rights Act, and gay marriage. Justice Ginsburg once said of those who would attempt to anticipate the court's rulings that those who know don't speak, and those who speak don't know. And the court, as it usually does, managed to surprise, please, and outrage many. We'll look at this week's big rulings when the broadcast continues in a moment.
Hi, I'm Leon the Lightning Lion, here to tell you, when thunder roars, go indoors. Thunder is loud, but lightning is dangerous and can hurt you even before it rains. When you hear thunder, go indoors quickly. Head for a house, school, or large building. If you're caught outdoors, get in a car, truck, or bus. Never go under a tree. Stay off telephones, computers, and video games. Remember, play it safe. When thunder roars, go indoors. Brought to you by these partners in lightning protection and lightning safety.
Engine.
Check.
Thrusters.
Check.
Fuel.
Check.
Computers.
Check.
Social Security.
No check, go direct.
That's right, Patty. A few weeks ago, I went online to godirect.org to sign up for direct deposit. It's easy to do, and I got my cash at warp speed.
Wow, it's fast and easy. I'll sign up right now to make sure I'm prepared for our next mission.
It's the last week in June, and the Supreme Court has weighed in with its most important rulings of the term. The court this week issued 3 highly anticipated rulings, all on the subject of minority rights and how they affect the rights of the majority and the nation as a whole. Kristen Jones joins us to discuss this week's rulings.
Michael, thank you. On Monday, the Supreme Court issued a ruling in the case of Fisher versus University of Texas. Abigail Fisher sued the university on the grounds that she was denied admission based upon her race. Fisher is white. She was denied admission, she claimed, so that less qualified minority students could be admitted to increase the school's diversity. Fisher lost in both federal district court and in the Court of Appeals. The Supreme Court agreed to take the case last year and heard oral arguments this winter.
The court issued a mixed ruling, vacating the lower court rulings and ordering the case back to the appellate level. In the case of Grutter versus Bullinger 10 years ago, Justice O'Connor wrote that race may be used as a factor in admissions only when all other methods of promoting diversity have been exhausted. This standard is called strict scrutiny. Writing for a 7-1 majority, Justice Kennedy wrote that the appellate court failed to apply that standard in the Fisher case. The result is that the matter will be remanded back to the appellate court for further proceedings. The litigants will likely be back at the Supreme Court in a couple of years. Both sides claimed victory. Conservatives cheered the reversal of the appellate court. Liberals celebrated that affirmative action survived being swept away. Only Justice Ginsburg dissented in this ruling. Justice Sotomayor did not participate.
On Tuesday, the court issued its next major decision in the case of Shelby County versus Holder. Shelby County, Alabama, is forbidden by Section 5 of the Voting Rights Act to change its election laws or rules without approval of the Justice Department or a Washington, D.C. District Court. Section 5 was created to ensure that areas of the South where racial discrimination was rampant could not create new laws that would infringe upon minority voting rights. Shelby County sued to have Section 4B and Section 5 of the Act declared unconstitutional, because they created a different standard for some areas of the country that other areas were not subject to. Shelby County lost in district court and at the Court of Appeals.
The Supreme Court saw things differently. In a 5-4 decision written by Chief Justice Roberts, the court struck down Section 4B of the Voting Rights Act. Section 4B lays out the formula that determines what jurisdictions are subject to the requirements of Section 5. Roberts noted in his opinion that the formulas used are the same ones that Congress used in 1965. Roberts noted that America is a very different place today than it was 48 years ago. He further wrote that Congress could change the formulas to reflect the world of the early 21st century. But using a 50-year-old standard was unacceptable. The court split along its ideological lines. Roberts was joined in his opinion by Justices Kennedy, Scalia, Thomas and Alito. Justices Ginsburg, Breyer, Sotomayor and Kagan dissented.
On Wednesday, the court waded into a place it usually loathes to go: societal issues. Gay marriage was front and center. First, the court released a ruling on the Defense of Marriage Act. Passed in 1996, the Defense of Marriage Act denied federal recognition of any marriage that was not between one man and one woman. It seemed to be only a theoretical exercise at the time because no states allowed gay marriage. By late this summer, 12 of the country's most liberal states will allow it. The Defense of Marriage Act was challenged by a New York woman named Edith Windsor, an 84-year-old lesbian who was forced to pay federal estate taxes on a large inheritance left to her by her lesbian lover. If they could have been married, there would be no tax. Windsor won at both District Court and the Court of Appeals. The Supreme Court agreed to take the case last year.
Again, the court's liberal wing divided against its conservative wing 5-4. This time, Justice Kennedy sided with the 4 liberals and wrote the opinion. Kennedy wrote that the Defense of Marriage Act unfairly denied Miss Windsor her right to equal protection under the law. It also violates the Constitution's Article 4 requirement that each state must honor contracts issued by another state. Justices Roberts, Scalia, Thomas and Alito dissented. In an unusual footnote, the dissenting opinions in the case are actually longer at 47 pages than is the court's opinion, which is only 30 pages long.
The Supreme Court then issued its ruling in the case of Hollingsworth v. Perry, the case against California's Proposition 8. In 2008, California voters passes a state constitutional amendment outlawing gay marriage by a 52-48 margin. But Governors Schwarzenegger and Brown refused to defend it. Private interests stepped in to defend the amendment. The District Court and the Court of Appeals both ruled that the defendants had no standing to take part in the case. The Supreme Court agreed to take the case last year.
The court issued a 5-4 ruling agreeing with the lower courts. But it vacated the appellate court's order striking down Proposition 8. It appears to leave in place though the District Court's order, which is based on different grounds. For the moment, it appears that gay marriage would be able to resume in California. But the court left wide avenues open for further lawsuits, which will almost certainly occur. The court's division was not along its normal political lines. Justice Roberts wrote the opinion joined by Justices Scalia, Ginsburg, Breyer and Kagan. In opposition were Justices Kennedy, Thomas, Alito and Sotomayor. In another unusual footnote, the plaintiffs' attorneys were David Boies and Theodore Olson, the 2 lawyers who opposed each other in Bush v. Gore.
Some of these rulings will send many in Congress scurrying to draft legislation. Senate Democrats are already chomping at the bit to rewrite Section 4B of the Voting Rights Act, so that the Justice Department can continue to obstruct voting reforms in the South. Meanwhile, lawyers will be racing to file new briefs in the appeal of the Proposition 8 matter in California. And other lawyers are getting ready to retry Fisher v. University of Texas with the future of affirmative action on the line. It's not unlikely that several of these cases will be back before the court in fairly short order.
Thanks, Kristen. Another fascinating June at the Supreme Court. We'll be back with closing thoughts when the broadcast continues in a moment.
When you drive for a living, you buckle up every time, whether you drive one of these or one of these. Truckers know what I'm talking about because no matter how good a driver you are, trouble can still happen. That's when you want to keep your safety belt on to keep you steady, behind the wheel, in control, and looking out for everybody. Safety is a professional driver's responsibility. Remember, you're the one who drives for a living.
A message from the U.S. Department of Transportation.
What if I didn't come from a famous family? What if I didn't have all their support? What if I didn't have all these opportunities? Believe me, It wouldn't be pretty. Pause before you play.
It's been more than 2 months since we've been able to bring you an original Borgcast. We are glad to be back and appreciate your patience. Daily Borg is created by one hard-working conservative who must work long hours because liberals need his tax money to subsidize their dependency society. Creating the Borgcast can also take up to 3 hours in any given day. That's time we don't always have. But we do look forward to having the time to create these videos to bring you cutting-edge analysis and conservative opinion, not for the low-information voter, but for the thoughtful. You have been assimilated.